right, you were in D.C. before you came here.
I was.
So you were in the D.C. circuit.
I was in the D.C. circuit.
Just to give you a quick follow-up on that one, you probably saw a lot of minorities in the courts when you were there. And is there, and I don't want to take a lot of time, so I don't want to unfair this, but does that give you some experience in going into this? Were there experiences from DC that might help you to work in this area more than, say, a lot of judges who have not had a lot of experience?
Definitely. I mean, I was in DC Circuit Court every day representing kids in the abuse and neglect system. And it was really going from working in the circuit court in DC and seeing those kids to working in the criminal justice system here, seeing how closely the lives of the criminal defendants track the lives of those kids in the abuse and neglect system, and wanting to be in a role where I could really make a difference and divert those kids from ending up as defendants that made me be a judge. So it has a huge impact on me.
Thank you. I want to, and just keep on here for a second. We got the next question, which may actually grow right out of that, is what were the most important cases you tried as a lawyer and why?
You know, I handled multiple cases involving abused and neglected kids in Washington, D.C., and I handled well over 200 appeals, largely involving the victimization of women and children as an attorney at the State Department of Justice. These were all extremely important cases. One case that really stands out in my mind is a case called State v. Marinez. It was a case that I took to the state Supreme Court. There was a 4-year-old girl who had been sexually assaulted by her stepfather. He'd also burned her hand so badly that they declubbed. That means all the skin came off. She had to be airlifted to the UW hospitals. Now, they do forensic interviews, videotaped interviews of young children, and frequently those are played in court. Well, she's a 4-year-old girl. She couldn't tell when exactly, date or time, that she'd been sexually assaulted. She could explain, however, that she was sexually assaulted before the hand burning happened, and police knew when that hand burning had happened because of the medical intervention that she needed. Now, in the videotaped interview, she used the hand burning, or they used the hand burning to pin down the time of the sexual assault. The Court of Appeals reversed the conviction, saying that all those mentions of the hand burning should have been redacted. That should not have come in. Well, I fought hard to petition that case, took the case to the Supreme Court, and I ended up winning the case. This was significant for several reasons. Number one, it was significant because it saved that child victim and her family from having to undergo another trial. It was significant, too, on a personal level. A lot of my colleagues were a little hesitant about taking the appeal at DOJ. I pushed hard to take it because I knew under the law, of my research of the law, that we had a good chance of winning. So it was just proof of my moxie and independence of making a good legal decision. Finally, it was important because it really helped open the law and make it more accessible to children. Child witnesses are a lot different than adult witnesses. For one, they can't tell time. And but if we want the justice system to really be all-inclusive, to cover everybody, to cover these children, we need to have those accommodations. So that case really stands out to me.